Good afternoon and welcome to our webinar today. Our webinar is called Reasonable Suspicion. What we're going to be talking about is managing your company's drug and alcohol policy. My name is Michelle Lanter-Smith. I'm the Chief Marketing Officer here at EPAY, and joining me is Anna Pager. She is our SPHR certified HR advisor and account manager here at EPAY. Thanks for joining me today, Anna.
Oh, thank you so much for having me, Michelle.
Well, let me tell you a little bit about Anna. Anna's been with us for about a year now, but she's been in the HR industry for 10 plus years. Isn't that right?
That's right, over a decade. Don't age me that much, though.
Working with a lot of different clients and helping them understand their HR liabilities, compliance risks, and then just helping to really boost employee engagement.
Absolutely.
Yeah. So today we have a really exciting discussion. We got registrations very quickly on this one, so it must be near and dear to a lot of folks' hearts in trying to understand what this is all about. And what Anna has kind of told me is the landscape keeps shifting underneath us and what you can do and can't do. So Anna is promised a really jam-packed session with some good information. But what I'm going to cover first is I'm going to tell you just a minute or two about who EPAY is. And then Anna's going to tell you why you need reasonable suspicion to take any type of action, and then discuss the procedure. She actually has a step-by-step process of how to handle a situation when you think and suspect someone is under the influence of alcohol or drugs. She's going to talk about compliance with the ADA and FMLA. And then we're going to talk a little bit about marijuana, obviously, because it is becoming more and more legal across our country, and it's creating some different situations for HR folks to handle. Now, we also are going to take your questions. We're going to take your questions at the end. We promise to leave a lot of time so you can do that. On the right side of your screen is a question box. Just type in your question and I will read it out to folks and Anna is going to answer it. You'll also at the end receive copies of the slides, so that's good. And Anna has created a special reasonable suspicion checklist as well as our HR department. And we'll also give you a link to this webinar recording, so if you want to listen to it again or if you want to forward it on to someone else, that'd be great. You'll also receive SHRM credits for this session, so keep an eye out for those. Let me just tell you a little bit about EPAY Systems. We're a Chicago-based firm, headquartered here in the Windy City, and we've been around since 2001. We provide human capital management software and services to our clients. So that means HR and time and labor and payroll software. We have an end-to-end solution. We have clients all around the nation. What we tend to specialize, though, are in clients that have an hourly blue-collar workforce. Now, why is that? Well, because quite honestly, that workforce is special. There's a lot of demands, HR demands, a lot of time tracking demands. It's not easy to get people to agree and to be compliant with time tracking systems. You don't have a lot of IT resources. We especially focus on clients that have a distributed workforce. So those employees are moving around from site to site, customer to customer. And that's a tough way to manage employees, track employees, and pay employees. That is our world. Those are the customers that we love to have, love to serve. You can see some of our customers there up at the bottom of the screen. And they range from very, very large clients, clients like the Department of the Army, to also small clients that are in the business services, manufacturing, distribution type of space. We offer 24/7 support to our clients, and our customers love that support. All clients get premium support when you come from EPAY, which really sets us apart and is why we have a great customer retention rate. Plus Anna's one of the reasons too. All right, well, our legal department says I do need to go over this slide really quickly and just remind you that the contents of this presentation should not be construed as legal advice or as a legal opinion on any specific facts or circumstances. These materials are intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. All right, now that we've gotten that over with, let's talk about the topic at hand today and talk about reasonable suspicion. Anna, tell us, why do you need reasonable suspicion? Where did this whole idea of reasonable suspicion stem from?
So let me kind of take a step back. Prior to 2016, employers would often, if you had a workplace injury, the process is typically you're going to the doctor and you're going to get a drug test. So what this did is this actually discouraged employees to come forward with any worksite accidents. So they weren't coming forward and they weren't reporting their injuries. And particularly this came into place, for example, I don't know, you have a press worker who needs stitches. That's a common injury in the press industry. It's not necessarily that they were under the influence of any kind of toxin to require them to have a drug screen. So it's wastefulness, and again, it discouraged employees to come forward. So OSHA came out in 2016 and said you have to have an element of reasonable suspicion to send somebody for screening. So that's where this stems from.
Oh, okay. Well, I think it's important, before we get into too much meat today, is just define, what does it mean to be under the influence?
Correct. So what does it mean to be under the influence? So we're talking here about people that are intoxicated, whether it's be on alcohol or drugs. It could just as easily be over-the-counter medications, such as cough syrup, prescribed, or illegal.
Oh, really?
Mm-hmm.
Okay. Now, we have all kinds of laws in our country, federal and state. Let's start with the federal government. Are there any federal rulings that regulate drug testing?
So not for the private sector, at least. The Department of Defense certainly has different rules and regulation, as does the Department of Transportation, as public safety is an issue in those matters. So for the private sector, at least, no.
No. Okay. Well, what are some of the common scenarios for testing? What are the different reasons employers test?
Sure. So typically employers would do a pre-employment screening. So, you get your background check, you do a pre-employment screening. It kind of helps limit your liability as an employer when you're doing these things. Reasonable suspicion, so, you have a situation where it appears that an employee is intoxicated. I'll walk you through those steps, but that is definitely certainly why an employer might screen. Post-accident now also has an element of reasonable suspicion involved in it. Return to duty, so if an employee was out for, an FMLA leave, and they're returning to duty, it could be a policy of the companies to make sure they're drug-free and alcohol-free before returning to duty. And then ultimately there's random testing as well. Random testing right now, because of all the new laws, medical marijuana, it's a little bit controversial, except for DOT. The Department of Transportation still does random drug testing.
Okay. All right. So are all these types of testing, are they allowed in every state?
Actually, no. What may be allowed, pre-employment screening is allowed in most states, but it may not be allowed in, for example, return to duty may not be allowed. So it varies from state to state. So you'll have to check your ruling in your state to determine what is appropriate in your state. Arizona, for example, has a condition that employees can contest or explain a positive result. And one thing I will note, many states do require confidentialities and make sure that those records are maintained throughout the process. I always recommend confidentiality. Ultimately, you don't want to embarrass anybody, and what if you're wrong at the end of the day?
Exactly, because mistakes do happen. So, going to put a little plug in for EPAY, as we are an HR and payroll software vendor. All of our human capital management clients receive the EPAY compliance portal. How have you seen your clients use the compliance portal to help them with figuring these things out?
Well, they can certainly look up the compliance within their state using our portal. It really comes in handy. And you actually get settings, so you can actually notify what state you're in, and you'll actually get notifications of law changes.
Very helpful, very helpful.
So today we're going to talk about the procedures that we need to follow to document and verify reasonable suspicion. But before we can handle any reasonable suspicion, you have to have a clearly written policy. Your drug and alcohol-free workplace policy is really key. It has to be in your employee handbook, and you have to have an employee handbook acknowledgement on file. Without that, really, you have nothing to go on. As mentioned before, a lot of this depends on your state, the type of testing, or even what your company industry is in. So you don't want to take maybe my word for it. You might want to check with your legal team as well.
I wonder how many folks on the phone may be asking themselves, do we have a handbook? Is it up to date? How do I pull it together?
And can I find my handbook acknowledgement from every employee? The electronic portal helps with that, by the way.
Yeah. Another plug, that acknowledgement can be kept in the system so that people that and you have an electronic document. It's
exactly.
In the system that
makes it so much
that they acknowledged it. Yeah, definitely. All right. Well, you have put together a great step-by-step plan that helps, I think, the folks on the phone really know exactly what you got to do when you're faced with this situation. So let's start with your first step. If you receive a complaint about an employee, what do you do?
Well, the very first thing you want to do is thank that employee for coming forward and actually take their statement. You want to make sure you're aware of when this happened, who it's regarding, and where it happened. You want to make sure you're asking specifics. For example, they can't just say, Susie Q is drunk over there. Why? What indicates that she's drunk? Tell me what you've seen. Is she stumbling? Does she have slurred speech? Do you smell anything? Take their statement, document it obviously, and ask if there's anybody that you've seen around that could collaborate the story. Ask that employee that question. And also make sure to ask if this has happened before. Perhaps this is just the first time that they're coming forward because they've had enough at this point. So those are important things to know.
Okay, so what happens if an employee makes a complaint, but it happened last week?
That's a good question because timing is very essential in these kind of matters. As you can imagine, if you're under the influence of something today, right now, if I go in and take a test and I'm drunk, it's going to come in clear. But if it was last week, that test result
you're on shaky ground.
Exactly. Well, the test is going to be negative. So what you want to do is you still want to document that. You want to keep what I call a cold case file, an investigation file, basically, for that employee. You still want to go over and investigate the issue, but likely you're not going to see any of the symptoms of the employee being under the influence. So you just document that, and should it happen again, you have a document trail of a repeated behavior.
Okay.
So again, observing. So when we're observing, I have a reference checklist that everybody will receive, but I want everybody to be able to reference that checklist. You're going to go in, you're going to observe that employee from afar initially. You're going to see how they're interacting in that workspace. Are they stumbling around? Are they doing what they should be doing? Hopefully they are, but in case they're not, then you want to go talk to the employee, investigate it a little bit further, see what you can determine on the conversation, if their speech is slurred, are their eyes dilated, anything that you can know, you would go back into the checklist and complete.
Now, when you go to talk to that employee, should you mention that there's been a complaint? How much should you tell them about your investigation?
That's a very good question. Initially it's just hearsay. So there's no need in setting off alarms for that employee because it's just hearsay. You don't really know what happened. It could be, just that the other employee is mad at them and wants them to get in trouble. So you don't want to say anything just yet. Plus, you don't want to set off the red flags going off and that employee is going to change their behavior based on what you just said. So you just want to keep it neutral for the time being.
I see. Do you need to have training to identify signs or symptoms of being under the influence?
So my personal preference, if it comes to litigation, it's best to have a good defense. And the best defense is to have training. Certainly having a checklist helps. But when it comes to litigation, the question that an attorney is going to ask you is what qualifies you to make this determination. And if you are certified in this, then certainly that qualifies you. You can explain that, you know what it looks like, but that
Mm-hmm.
we want to have a strong defense ultimately. So I personally think that training is necessary.
Where do you get that training?
Good question. DOT offers that, as well as the Substance Abuse and Mental Health Services Administration. By the way, these are not sponsored by them, so I'm just plugging them because they do offer the very great courses.
Okay.
Okay. So this employee that is under investigation, if they're operating any kind of if they're in a safety sensitive area, you certainly want to remove them from that area.
Mm-hmm.
You want to make sure that you're keeping your employees safe, and that includes all of them, not just that employee, but everyone around him.
So what type of situation should you remove an employee from? What have you seen?
So really power tools, heavy machinery, forklift operators, certainly you want to remove them from those areas. So we always recommend having 2 members of management make observations. For the other observer, you want to have them follow the same steps that you did. You want to reference the checklist and observe them from a distance, and then talk directly to that employee to make more observations.
Is it okay if you ask more than one person to make an observation with you?
You really shouldn't. Remember, at this point, it's just hearsay, and all the information you have, it can just get really messy if you have more people involved. So less is better in this instance.
Better.
Mm-hmm.
Okay, but you need the observations from another person.
Correct, independently.
And then should you make your observations at the same time together?
No, you don't want to influence the other person observing. So you want to make sure that those observations are done independently.
Okay. Do you want the observer to be someone who is familiar with the employee in question, or someone from another side of the plant?
It really, honestly, it's not necessary that they're familiar with them. It really is kind of irrelevant as long as they're objective. Okay, so we've gone through the steps. An employee has come forward, has lodged a complaint. We've made our observations. The next step is obviously to document our observations. So in the checklist that everyone will get, there's physical indicators. It'll discuss walking, the face, the speech, the breath, and it'll also actually have a little section that includes whether or not they appear normal. So they can go through this and kind of check off what applies to this position. And there's also space for commentary. So if there's anything additional, they seem perfectly fine, you can actually note everything in there.
Can you videotape an employee who is suspected?
Oh, Michelle, you love throwing hard questions. I wish I had a very simple answer for that one, but that is actually a very tough answer. So it's going to depend on 2 things. One, it's going to depend on your company's policy on video surveillance. If you do have a video surveillance policy, you likely have an acknowledgement form from that employee acknowledging that they're under surveillance. And this is all determined by your state, because states vary from state to state on video surveillance. So ultimately, if your state allows video surveillance and you have a video surveillance policy in place, you can certainly use that as a form of reference. I mean, I wouldn't go and use it as complete hard say evidence, because you can't really tell why somebody's tripping. You can't really tell what they're drinking, but you can certainly use it as additional evidence.
Okay. All right.
So we're going to assess the situation now. So there's 2 scenarios. One is you and the other manager agree, and you're either moving to testing or you're not moving to testing. That scenario is pretty easy and pretty self-explanatory. Where we kind of get the questionable results is when you both disagree. One individual sees something that indicates that they're under the influence, and the other completely disagrees. So what do? You need a tiebreaker at that point. So then you'd need a third party, and I'd recommend another manager, supervisor type of scenario. You really wouldn't want to get somebody involved that's on that employee level, because you don't want them to really know what's going on. But the third whatever the third person observes, that's what you go by.
So a manager, the third person, a manager is the tiebreaker.
Absolutely.
Okay, what do you do next, though, if you both agree that there is no reasonable suspicion at this time? You didn't see anything.
Well, then you just document that you didn't see anything. And you want to continue to document this because it could be, that employee that's reporting it could be actually trying to get this employee fired.
Yes.
Or it could be that you're just missing it. For some reason, you two are missing it, and there is a pattern. And if you develop a pattern in your documentation, you have that documented, so you can use it.
So you document it in their file.
I would use a cold file. So it's a separate file because it's not part of their employee file. It's a separate file.
It's a separate file, a cold file. Same thing, how about the person that brought it forward? Do you document that?
So you document who brought it forward in this cold case file.
Okay.
And that way you can kind of see what's going on if there's a long-term pattern establishing.
Very good. All right, you think of these things, I don't. So if the manager is the person behind a complaint, can the manager also be one of the observing personnel?
Absolutely. The manager is in a position of authority, and ultimately, they're there to manage their team. They should know their team, and if they see something that's off, certainly they have the obligation to report it, and they can serve as a witness as well. So meeting with the employee, this is the most awkward conversation I think anybody can have.
I bet. How many times have you had to do this, Anna?
A few, unfortunately. A few. First thing I want to note is, again, confidentiality is key. You don't want to address this out in the open where other people are watching. You want to have them in a conference room or an office, somewhere where no one is really watching the scenario. You want to meet with them, and you want to have a witness. You want to let that employee know that a complaint has been filed. You want to go through your drug and alcohol policy with them and explain the procedures that you've followed, that you've had multiple observers and what has been observed. Allow that employee to respond. Whatever the response is, note it in the file, but just you still have to follow your process no matter what the response is. And have the employee sign off on the test acknowledgement form and share the next steps with the employee.
Okay. Can the manager who is involved in the observation process act as a witness for the meeting with the employee?
Absolutely, they can. You don't necessarily want to reveal that they were the observer or anything to that nature, but certainly they can.
They can be there, okay. Would you show the employee the sheet of observations?
I wouldn't show them the sheet. I would actually, if they wanted to have a list of what was observed, you can provide them with that list, but I wouldn't show them the actual checklist because it's going to have the person's name who observed.
Okay, so the checklist is meant for the cold case file, it's meant to take your notes, but it's not something you should show the employee that's under question, but you said you can give them a list of the
correct
behavior.
Correct. What was observed. You can let them know what was observed. And one thing I'd like to note too is, this is an awkward conversation you're having, and you want to put that employee at some sort of ease because, first of all, you don't really know what happened, even though you've observed. You don't know their scenario. Mm-hmm. So I always recommend using some terminology saying, we're going to send you for testing to rule out the possibility of violating the drug and alcohol-free policy. That way we're assuming innocence as opposed to guilt, so it gives them the opportunity to be ruled out of using this possibility.
Okay. All right. Well, this testing acknowledgement form, what's the purpose and the benefit of having a testing acknowledgement form like the one that's on the screen right now?
Sure. So again, go back to your policy. Policy is key. You have to have it written into your handbook. You have to have an acknowledgement. Without that, even this acknowledgement form won't hold any water. All this is doing is reiterating to that employee that they've been informed and what the policy and the process is. It all serves as a reminder so that they don't come back and say, I had no idea what the policy was, because oftentimes, I'm sure anybody in HR will have heard that at least 10 times in a day. Mm-hmm. I didn't know that was the policy.
Okay.
So the next step is really to prepare transportation. And I see this mistake made many, many times, so please don't be the one to make this mistake. If you're assuming that that employee is under the influence, don't let them drive themselves to anywhere. It's just kind of like if you have a friend that's visiting and you think that they've had too much to drink, you wouldn't hand them their keys and say, okay, have a safe drive home. You want to make sure, and particularly, as a company, you could be held liable for any accidents, and you want to guarantee that they're safely arriving to their appointment. So if too much time passes, too, this could be an issue. So you want to get them to that appointment as soon as possible for screening.
So you can observe it, and then you can say, we need to rule out that you're not under the influence, and you need to go now. I got a taxi waiting.
Exactly. You can have a taxi, you can have a manager take you. Whatever the case is, you just want to get them there safely.
Really? You can really have a manager take them to this facility to get tested?
Absolutely. You just want them to arrive safely.
Okay. What about public transportation? What do you think of using that?
Again, time is key in this instance. You don't want to give that employee an opportunity to flush out whatever's in their system, and you don't want them to go and, get hit by a bus on the way. I say that kind of comically, but it can easily happen, and you don't want to live with that guilt or, liability either. So, no public transportation.
So call Uber.
Cab, Uber, whatever. Yeah, absolutely. Just get them there.
And pay for it.
Absolutely, pay for it. So one thing to note, too, you want to notify your testing facility that they're coming. Most will require some sort of authorization. And you want to work out all the transportation. So not only are you getting them to the facility, you want to make sure that they have a safe way to get home as well. So be it Uber, a cab driver, or a manager, last call. Either way, you're paying for it. The company is picking up that bill. Include the tips. Don't expect the employee to make any type of payment here.
Yeah, because the employee probably not going to be too happy about it.
No. Certainly not. Certainly not. So we're waiting for the results now. You followed all your steps. You had the employee. You filled out the documentation. What you want to do is you want to be prompt and document the contact with any testing facility. And, you've worked with your facilities before. You know the response time, be it 24, 48 hours, but you also know your facility. If they get bogged down, they might be a little delayed. So you want to reach out to them and follow up as well. But you also want to keep the employee in the loop. Let them know what the average turnaround is and what they should expect.
Okay. So I got a question for you. A lot of our clients, labor is of a shortage. Can the employee come back to work before you get the results?
No, I know that, when you're short-staffed, I feel that pain a lot, but no, it kind of defeats the purpose of the whole, I'm sending you out for testing because you're under reasonable suspicion.
Well, what if then the tests come back and they come back negative? Good news.
Ooh. So let me just kind of step back and say that, if you've followed the process, is very unlikely that this could happen. But there is that realm of possibility that, it could happen, certainly. So in that rare instance that it does happen, you want to contact that employee and let them know when they can come back to work, what their next scheduled shift is, and you want to back pay them. So for whatever time that they've missed, you want to pay them for that.
Yeah, you got to try to make sure there's no hard feelings. So right away, I would assume the message is, we're going to pay you.
Absolutely. Absolutely.
All right. Well, you said that most of the time, if you followed the process and you've sent them off for testing, the results are positive, right?
Correct. And so we're going to go through that scenario. And the result comes back and it's positive. Again, comes back to your policy, but you want to offer something to that employee, be it an employee assistance program, provide them some sort of contact information on how to get help if they need it. Offer them a last chance agreement if you can. Basically what that does, it allows that employee to seek counseling or treatment or both, whatever they need. And I would actually run that concurrently with FMLA so that, if they need to come back, you also want to make it clear to them that should this happen again, that is your last chance and it's going to lead to termination. You want to seek legal counsel if you question any of this, and particularly in your state. Or if your policy is zero tolerance and you terminate people immediately, make sure that's stated in your policy. and practice it consistently.
All right, well, step 10, you decided they need a test and they refused the test. So then what happens if they refuse the test?
So again, refusing a test, it's key to have this in your policy. You have to have it outlined what happens if they refuse the test. In most cases, I would recommend having an automatic positive result leading to an automatic termination.
What if the employee insists on driving home?
Oh, this can happen quite a bit. One thing you have to keep in mind, you don't want to restrain them. You don't want it to get into a physical altercation in any way, shape, or form. If possible, ask them to sign an acknowledgement form attesting that they're refusing to take a ride or get a cab ride or anything like that, if possible. Now, usually they're not going to sign anything. They're going to storm out.
Okay.
And then if that's the case, if you don't have this information on file, you want to see what kind of vehicle they're driving, what their license plate is, and actually report it to the authorities, because now they're endangering the public.
Definitely. All right. Well, then what if the employee refuses to leave after the termination? You said you refuse to take the test. Goodbye.
Yeah.
You're fired or terminated, and then they're like, I'm not leaving, and something happens.
Absolutely. This scenario unfortunately does happen. So it does, depend. If you have maybe security in your building, then you can have security escort them out. If you don't, feel free to call the authorities and have them physically removed if you need to. Treat them just like you would any other employee that you're processing a termination form, because disgruntled employees do happen, unfortunately.
Well, in the beginning, when you told us about how reasonable suspicion started, it was around the whole idea of work accidents and trying to find out if a work accident happened because of being under the influence or not. So what qualifies as reasonable suspicion if there is indeed a work site accident?
That's a good question. And sometimes it's actually the accident itself that could be considered reasonable suspicion. In my earlier example, you had a press operator that got stitches. Not necessarily something outside the ordinary, but let's say you have a forklift driver. Forklift drivers should have a clearly marked path in where their facility is. If they weave off that path and, fall off a ramp, that in itself would qualify, in my mind, as reasonable suspicion. But not only that, you want to interview in your investigation any witnesses and take note of their statements. So if somebody says, yeah, I smelled alcohol on his breath earlier, but I didn't get a chance to report it earlier, make note of that. That in itself could also be considered reasonable suspicion. So again, key is documentation during your investigations. So reasonable suspicion and the ADA. I want to be clear here that the ADA does not prohibit employers from maintaining a drug and alcohol-free workplace. It does not protect employees who violate a drug and alcohol-free workplace policy, and it does not require to offer any kind of last chance agreements, and it does not protect any employees who are using illegal drugs. These are things that it just simply does not do, to be clear. What it actually does do, it protects qualified employees whose alcoholism meets the definition of a disability. It protects employees in a drug or alcohol abuse rehabilitation program, and employees who have a history of substance abuse from discrimination in hiring or firing or promotion. It really protects employees who have disabilities which have overlapping symptoms of intoxication. For example, diabetes, low blood sugar, and mental illness could certainly have symptoms such as slurred speech, disorientation, or a lack of coordination. What you want to do if that sort of situation arises, you still want to follow your process, but you don't want to single out these employees and continue to run them through the process as they're going to be covered under ADA.
Okay. And certainly those type of diseases and things like that can make it look like you're under the influence.
Certainly, absolutely.
Yeah, definitely. All right.
So with reasonable suspicion in FMLA, this is the textbook definition of FMLA. Employees that are eligible may use leave to deal with substance abuse issues, treatment of drug and alcohol addiction, treatment of another physical illness related to substance abuse, caring for a family member who's being treated for these issues.
Oh, really? A family member, too?
Absolutely. Employers cannot retaliate against these employees. You shouldn't, because somebody's out on this kind of leave, you don't want to fire them or refuse to hire them or refuse to promote them. The key here is to really to remember that employees with a history of drug abuse, it really doesn't stand for reasonable suspicion now. So just because they have a history of it, it doesn't qualify them to have reasonable suspicion.
Okay.
Make sense?
Yep.
Perfect. So, medical marijuana. If you guys can't tell, this makes me a little nervous. It's very interesting to see how this is going to unfold because the laws are changing here, and they're changing very rapidly. With medical marijuana, or marijuana in general, unlike alcohol, marijuana, the impairment of it is really hard to detect in THC levels. So everybody responds to it a little bit differently. So with alcohol, the police use, a percentage of what level you're at to see. With marijuana, they can't detect what intoxicates somebody, what level it takes.
What level you are, how much.
Exactly.
Yeah.
So it makes it much more difficult. So that being said, a little side note, 10 to 25% of employees are sometimes on the job under the influence of either alcohol or some illicit drug.
What? 10 to 25%?
Yeah.
Up to a quarter of your employees?
Yep. Look around. Take a look at who's having a liquid lunch. Now, another thing to note here is states where recreational marijuana is illegal. Currently, those are Colorado, Washington, Oregon, California, Nevada, Massachusetts, and Maine. So one thing that I want to know, for all those states that have recreational marijuana as legal, you can still have a drug and alcohol-free workplace policy and maintain that. So again, as some of these laws are being developed, we'll see where it all lies, but you can certainly have a policy to protect your employee population.
So someone someone that's drinking, you treat it the same way. If they're over 21 and they're an adult and they can drink,
absolutely.
If they're over 21, they can use marijuana.
Absolutely.
But if you have a safe-free, drug-free environment, you can say as an employer, I don't want drinking, under the influence of drinking or marijuana.
Absolutely. The only downside of that is the testing. So that's what makes it gray.
Yeah.
That's what makes it very gray. So going on, I have a couple cases that I'm keeping an eye on personally. In 2009, Roe versus Teletech Customer Care Management, there was actually a decision, and the decision here is actually for the employer. In this instance, it was medical marijuana was being used to treat migraines, and the employer did pre-employment screenings. And the test results obviously came in positive. They rescinded the offer, and the decision was made with the employer that they have the right to maintain their drug and alcohol-free workplace policy. So 2018, we now have a new case to look at of Nosfinger versus the Bridgebrook Nursing and Rehabilitation Center. And currently there's a summary judgment, which is not a final ruling. But currently it looks like they're favoring the plaintiff. And in this instance, it is also a medical marijuana instance where the employee was doing a pre-screen, and she disclosed that she's taking these capsules of medical marijuana because she has post-traumatic stress disorder, and it helps her sleep. So she's taking that to help her sleep. But they also have a drug and alcohol-free workplace policy. And you have to keep in mind, too, she's working in a nursing home. So it's actually going to be very interesting to see what the final ruling is on this. I do find it very interesting how these states are going to handle these issues in the future. It's definitely going to shape our laws, and I'm very interested to see how it goes.
It's going to be interesting to watch. So as this how do you keep up on this, that you recommend our listeners keep reading up on it so that they know?
I subscribe to a lot of
journals.
Yes, thank you. Thank you. I had a little brain knack there. Absolutely. Sure. And I keep, our compliance portal also keeps me in the loop too, because I get notifications of a lot of these things.
Right.
Just from our compliance portal alone.
And then we also have clients, when they buy our software platform and administrative services, one option is to also choose to have an HR generalist be on the account and provide those HR services.
Absolutely.
So they can call in and get these questions answered. Yep. Yeah. All right.
So now we've covered all the steps and what should everyone take away from today. Ultimately, what's next? You want to look at your employee handbook and your current policies. If you don't have one, that's okay. We have a template for you. But if you want to write your own, you want to make sure you're asking the important questions. Who's going to be tested? When are you going to test them? And what are they going to be tested for? And ultimately, you want to make sure you're spelling out what the consequences are for a positive test. Like I said, you can certainly download our template. If you have questions in regards to compliance, our clients all have access to the compliance portal, which is a big help to go through the rulings of each state. Ultimately, I would like everybody to take away some training, go and seek it out, because being able to identify these signs is key. And make sure you train your managers. I mean, ultimately, they're the first and last line of defense for you guys in reasonable suspicion.
Definitely. Well, before we get to Q&A, we have some scenarios that our team have put together. And let me read them to you, and then you tell me what you think, how you should handle it, okay?
Sure.
All right. So a supervisor receives an email from an employee stating that he thinks Dave, another employee in the department, is coming to work drunk. The email states, on Monday, Dave smelled like a brewery. It is now Thursday. The supervisor talks with the employee to get more information, so we have a few days gone by, but there are no other witnesses. How would you handle this scenario, Anna?
And that, I think, is a common one, because oftentimes employees don't necessarily want to be, the snitch, but they've thought about it and come forward later. So you want to thank that employee and say, thank you for coming forward with your concerns. I'd ask them that if this happens again to come forward immediately, be it to your HR manager or your your direct manager, whoever is the department head. Then I would recommend that you document the issue. Meet with Dave and see if there are any observations that you can, and see if, it's unlikely he's going to be under the influence at that point in time, but you still want to make sure that you're documenting the situation. And again, that would be a cold case file. You would see if there's a pattern in behavior in the long run.
Okay. All right. Well, here's another case. You have an employee who comes into his manager's office and reports that Cheryl, the forklift driver, seems very disoriented and has red eyes, and he thinks she might be drunk. The manager sends the employee to report to HR while he goes to observe Cheryl. After noticing these similar symptoms, he knows that he should remove her from forklift driving duty until he knows more. How would you address Cheryl in this case and remove her safely?
Okay, well, first of all, the manager should be the one removing her and reassigning her to a different role. So, if she's a forklift driver, reassign her to inventory or, something for that day. That's not going to be.
And does he have to say why?
No, absolutely not.
Okay.
So it's a need of the business at the moment.
Okay.
Okay.
All right, I've got one more case for you, one more scenario. All right, what would you do if, actually, no, I have another question for you on Cheryl. What would you do if during the sit-down meeting with Cheryl, it's revealed that Cheryl has a cold and took some over-the-counter cold medicine? Okay,
so she comes forward and says, all right, you guys, I'm under the influence. I took cold medication. That's really what I'm under the influence. You still, like I said earlier in your steps, you want to note that. You still want to follow the process. It's best practice to do because, A, you don't know if Cheryl's lying to you. So let's rule out that possibility. But even if the tests come back positive and it's, you know, it's a minimal level of alcohol caused from cough syrup, you can handle that according to your process. Hopefully you have last chance agreement for her or something to that. I know it sounds extremely extreme, but I would still go through the process of sending her to get tested. And I mean, chances are if it's cough syrup, it might very likely come back negative anyway, but then you'd have a document trail.
Did you hear a lot? No, I wasn't drinking. It's cough syrup. I got a cold.
I don't know if I've heard cough syrup very often. I mean, that's not necessarily what it's been, but I've heard of no, not under the influence. Denial, denial, denial.
Okay, all right, one more scenario. Joan tells her manager that she suspects Steve had a few drinks at lunch. She had suspected Steve was drinking at lunch in the past, but this is the first time she smelled the actual alcohol on his breath. The manager asked Joan when she observed this and why she had suspected it before, if she observed any other concerning behaviors, and whether anyone else commented on this behavior or witnessed it. The manager then approaches Joe's workstation and asks him a few questions about the project he's working on. During the exchange, the manager observes the same thing, the smell of the alcohol when Steve speaks. Also, his speech is slurred and he seems a little flushed and distracted. The manager then asks the head of accounting to stop by Steve's desk to drop off some papers and chat with him. And the manager asks the lead to let him know if he notices anything odd. The department head returns 10 minutes later and says that something was definitely off with Joe. He was talking slower and sounded like his words were slurred. His desk was a mess, pretty unusual for him, and he was dropping papers and folders and even bumped into his coffee cup. They both document, okay, what they observed, and they call HR. So, Anna, what would your next steps be?
Okay. So I would review the observations from the manager and the department head, print off the drug testing acknowledgement form and a copy of the drug and alcohol policy. I'd agree that, you know, you have reasonable suspicion to send Steve in for testing. So I would certainly need to send them to reach out to the cab company and ask them to arrive there. Then basically call them up and ask them to come in about 30 minutes or so from the call. Then, you know, I'd call in Steve into a meeting with the manager, and I would explain that in ruling out the possibility that Steve's under the violation of the drug and alcohol policy, that we're going to send him out for testing. And again, explaining the steps of what has been taken. I'd ask Steve to sign off on the consent form and then let Steve know that there would be a cab to take him to the testing facility, and the cab would be taking home as well. It'll usually take about 48 hours to receive the test results, and according to the procedure, Steve will be called back to work after the test results come back. And an employee with negative test results will be paid for the days missed without waiting for the results. Steve, unsurprisingly, has a positive test result.
He does, huh?
Of course, in this particular case. And the company procedure is to offer a last chance agreement to the employee, and Steve accepts this. The company basically mandates that Steve is referred to EAP and he signs the last chance agreement and puts into the request. Wouldn't it be nice if it all worked out that way?
It was that easy. Yeah, there's a lot of pain and heartache to get to that point. But all right, well, this great information. We've got a few minutes left. Let's get some questions from all of our listeners today. So Dale asks, shouldn't your second observer be trained in reasonable suspicion?
Absolutely, Dale.
Absolutely.
Absolutely.
So does that mean for all management, should be trained?
I believe all management should certainly be trained.
Okay. All right, Ashley asks, for the acknowledgement, can we include the drug and alcohol policy with reasonable suspicion in the handbook, or do we need to have a separate acknowledgement?
You can certainly include it in the handbook. You can also, you can make it a standalone policy as well. It's up to you.
Okay. So Catherine asks, can you use a breathalyzer? I am assuming she means on site, can you just use a breathalyzer and say you're drunk or not drunk?
No. You want a third party to administer these tests.
Okay, so absolutely not. It's got to go to a lab. Do it that way.
Absolutely.
Okay. Catherine also asked, can you take action for arrest while not at work? So I think what she's asking is, if someone got a DUI or has been arrested but they're not at work, can you do something about their job if it didn't happen on the job?
So if it didn't happen on the job, it depends on a few things actually. That's a good question. It's going to depend on state to state whether or not, I actually probably wouldn't recommend it, but it depends on the state whether or not and what kind of position they're in.
Okay. From Carol, can the acknowledgement form just be a handwritten note?
Sorry.
Yeah, we got some all cut off, but can it just be a note? Oh, there we go. Stating they're refusing to take the cab ride.
Yes.
Yeah.
Yeah, I mean, if they're refusing to take it, certainly you can write that out. That is your documentation, certainly.
Okay. All right. And then from Christine, are there any further implications or responsibilities that an employer has if it is suspected or found that an under 21 aged employee is under the influence?
Minors.
Yeah.
So minors, really, you should be reaching out to their parents. That's what should be going on. We're going to research this a little bit more. Honestly, I haven't really worked with too many minors.
Okay, yeah. Well, that's one that we probably need to look in and talk to your authorities about.
Absolutely.
Yes. Okay. A question just came in from Terry. Our handbook does not mention a testing or last chance agreement. We have a policy, and it was reviewed by council. We say that we will refer employees to a drug-free awareness program provided by EAP. Do you recommend that these documents or processes be added to our policy?
Absolutely. I would you don't have to, but if it's your policy, then there's no reason that you shouldn't add that to your policy.
Okay. All right. We got Kate coming in with a minor. Would you call their parents first before doing anything? I guess we're kind of going back to that.
Honestly, again, I haven't really worked with too many minors, to be completely honest. But yes, and I'm speaking from a parental standpoint of view, I would like to know what my child is up to.
Yeah, and actually, as you know, a minor is under 18, but of course our drinking age is 21.
Excellent.
So that's something that, but instead of giving you the wrong advice, I think we really would rather research it. So we can do that and then follow up notes around this whole area. Anna and the HR team will look into that and just put a little paragraph in our email that goes out with the slides. How's that sound? Okay, good. Well, I just would like to go ahead then and wrap up. Again, just to tell you a little bit about EPAY Systems, we are a human capital management provider. We help you manage your employees from pre-hire all the way to retire, right? So that is in recruiting those employees that you need. Can be tough in this labor shortage that we have today. So we have a very good applicant tracking and onboarding system, as well as an HR system and benefit enrollment and benefit management system. So everything you need really to manage those employees. But again, if you have a hourly workforce, especially one that has some very complex pay rules, shift differentials, you got union rules, things like that, we have a very solid time and labor management system. We have been in the time and labor management business from the very get-go. This is workforce management is our specialty, and understanding this and being able to track employees. We help lots of employers not only save labor dollars because they can see right away where their overtime is. They can see visibly who's in, who's not in, who's changing time on employees, changing rates, things like that. But we also help a lot with compliance. Some of our large clients have the DOL knocking on their door. Well, you know this, Anna.
Absolutely.
Knocking on their door all the time. And because they're in our system and been on our system, everything is tracked, everything is calculated properly, and they've got all the documentation. And quite honestly, nothing usually goes to court when they have an EPAY system. We also have a payroll and tax management system, and we have a lot of administrative services to help you. So our clients, we can handle the full payroll for them, or some of our clients like to do most of the processing themselves, but we do all the tax management, ACA filing and compliance, and then other ancillary services like COBRA management, FMLA, you mentioned that today, garnishment administration, and so on. And I know you're really excited. We just added a performance management module onto our system, which is pretty key as an HR professional. Absolutely. Yeah. So that's a little bit about EPAY. Thanks so much, everyone, for joining us today. I hope you got a lot out of today's presentation. Anna, you did a phenomenal job. Thank you. Thank you. When you exit today, you're going to take a real quick survey. Let us know what you thought, and stay tuned for our future webinars. Anna does one every quarter, always on a different topic. We also do other types of webinars. I think our next webinar is coming up on background checks, going to be presented by Saifar Shah. Not too often that you get a free hour with wage and labor lawyers and finding out how you can get in trouble with background screenings. So go to our website. You'll see that's going to be coming up here shortly. We encourage you to take a 2-minute tour of our system and see what we're all about. And we'd love to work with you. Anna and her team would love to take care of you and give you a great platform that can help save you some money, but also help you in some of these other type of areas that she talked about today. So just let us know if you'd like to learn more about EPAY. Tell us you'd like a demonstration. So again, thank you, Anna. Really appreciate it. And, feel free to connect with us on our social media and so that you can stay in touch with Anna. And
follow me on Twitter. I tweet for the company.
All right. Follow Anna there, and you can stay in touch with what's going on. At EPAY, we would like to be your human capital management provider. Thanks so much for joining us today. Have a great rest of your day. Goodbye.